Preston Tate was a defendant who was convicted of several traffic misdemeanors in what was called the Houston Corporation Court, now the Houston Municipal Court, and he was an indigent defendant. He couldn't pay, and he was immediately sentenced to jail. It was actually a prison farm at the time, but jail. He appealed his case, and the U.S. Supreme Court heard his case and reversed his immediate placement in jail for the fine back in 1972. What the court had to decide is if someone is indigent and they owe a fine and they cannot pay the fine, can they immediately be put in jail for non-payment of the fine? The ruling of the U.S. Supreme Court was under the Equal Protection Clause of the 14th Amendment, you cannot put someone in jail for a fine-only offense. The court must consider economic status, and if a defendant is found to be poor, indigent, then the court is to look to alternative means of punishment. Alternative means, according to the court, can be something such as a payment plan or community service. The U.S. Supreme Court said very clearly that they will leave it up to the states to decide, but clearly jail time is not the main punishment if someone's found to be indigent and cannot pay a fine. Alternative means is an alternative to paying the fine, and it's also an alternative to going to jail. And it must be afforded to any defendant who the court finds to be indigent. During that time, and you will hear this phrase today, the term pay or lay is referred to if a defendant is indigent and cannot pay the fine, then he immediately defaults and the judge has him lay out in jail. The practice of pay or lay was clearly declared to be unconstitutional by the U.S. Supreme Court in Tate v. Short. In addition, the U.S. Supreme Court said very clearly that pay or lay, having someone either pay the fine or lay out in jail, is an illegal act by a court. A court must have an indigency hearing and provide alternative means to paying the fine, such as community service. You can, as a judge, sentence someone to a payment plan. They can have extensions on when they pay the fine. Or a judge, if someone is indigent, can sentence someone to community service. The community service must be done at a nonprofit or government entity and can't be over 16 hours a week. Juveniles also are covered by our statutes in terms of indigency and alternative means. The legislature has declared fairly recently that all juveniles, by definition, those who are under 17, are indigent. So, what can you do with juveniles? You can sentence them to community service immediately. Also, with juveniles, we're allowed to sentence them to educational tutoring to substitute for the fine. Juveniles actually are probably a good role model for how we treat adult indigent defendants, because juveniles by definition are indigent. One third alternative means of punishment for a juvenile, if the offense occurred on school grounds, is a judge can sentence them to educational tutoring to substitute for the fine. Of course, any juvenile under a deferred disposition sentence can do teen court or other educational reasonable activities. Number one, it's the law of the land, and judges are supposed to follow that law. What is the law? That judges are to hold indigency hearings, and if they find a defendant indigent, they're to sentence them to an alternative means such as community service. But secondly, Tate v. Short is relevant today because it tells the judge that you're supposed to be the one who understands the law. I will have defendants who will ask me, even beg me to do jail instead of community service, but they don't get to decide that. The judge does. And Tate v. Short is still the law of the land and said very expressly that pay or lay is an illegal act. If a defendant cannot pay immediately, then the court will look to see what the economic status of a defendant is. Often, it's very helpful for them to fill out a payment plan application. Once the defendant has filled out a payment plan application or spoken to the judge or a payment plan coordinator, then the court is to determine what would be an appropriate payment plan that the defendant can pay without going into funds that go to necessities, things to support children or the defendant, food, shelter, those type of items. A second alternative mean that judges can sentence indigent defendants to in replacement for the fine is community service. Community service at the minimum must be given a $50 credit for 8 hours, though a judge can give more credit per 8 hours of community service. Also, judges are limited to not assigning more than 16 hours of community service a week unless doing more would not cause a hardship on the defendant. For instance, perhaps a juvenile during the summer break will have more time to do more community service hours. But community service hours are limited by one thing, and that is that the community service must be performed at a government or nonprofit entity. Most judges in most cities have various nonprofit or government entities that would really benefit from the court's defendants performing community service at those various entities. And another thing I want to add is Chapter 45 is kind of our Bible for municipal court judges. And in 45.049 of the Code of Criminal Procedure, it gives you more information on who watches the defendants and supervises the defendants while they're performing community service. That nonprofit or government entity will supervise them and will report back to the court that the defendant did the hours. And it's really a good idea for either the clerks or the judge to verify to make sure that defendants did perform the community service once you give them credit for the fine. Looking into the next legislative session and future legislative sessions, municipal courts really do need to look at more alternative means than just community service. It's been my experience that all these alternative means almost always have a better result than jail time when we're working with indigent defendants. Some courts ask about waiver of fine and costs, and can you just do that when you find a defendant indigent? The answer is no. In order to waive fine and court costs, a judge must first find that a defendant is indigent, the defendant must have defaulted, and then the court is allowed to hear evidence that performing community service would be an undue burden on the defendant. A defendant who has been sentenced to the penitentiary. That defendant is indigent. They can't perform community service while they're in the penitentiary, so a judge could find that performing community service is an undue burden. Someone with a physical or mental handicap may be such that that handicap does not allow that defendant to perform community service. It could be a variety of reasons, and it's really up to the judge, but a judge has to go through the step of finding that a defendant who has defaulted is indigent, and then taking in evidence that performing community service would be an undue burden. Also, there may be some question about juveniles, because I've mentioned that juveniles are indigent just by the nature of their being juveniles. So the same law does apply to juveniles. If a juvenile defaults and performing community service would be an undue burden for that juvenile, and the court so finds, then the court can waive the fine and court costs of that juvenile's case. Sometimes I hear from judges who say, we don't have community service in our city. What can we do? Well, number one, most cities, most counties have nonprofit or government entities. They exist in almost every city or certainly nearby cities. One thing you can do is you can, or your court clerk could, call these entities and talk to them about who they will accept. Perhaps order defendants to specific entities, as long as you're not favoring one entity over another. But helping your community by providing them with defendants who can perform community service for these nonprofit or government entities is a wonderful way to improve not only your community, but also help defendants to make sure that they don't appear in your court. I have many defendants in College Station who leave and go to another town in Texas during their probation or during their sentence. And you can, as a judge, allow them to do community service in another town as long as it's performed at a government or nonprofit entity, and you can verify that they performed that service at that entity. The answer is yes, they can. First, any defendant, especially a non-indigent defendant who willfully refuses to pay the fine, can be committed to jail. An indigent defendant who has been sentenced to community service as an alternative sentence and willfully refuses to do the community service, and the community service is not an undue hardship, the judge then can commit that defendant to discharge the sentence in jail. What Tate v. Short means in my court is the judge is the one who must follow the law. And when I see defendants in jail, it's very important that I remind them and remember myself that the only punishment for a Class C misdemeanor is a fine. And so those defendants who cannot pay a fine, I must do an indigency hearing. And if I find that a defendant is indigent, then I must provide an alternative means, which is community service, for those defendants to discharge the fine. It's been my experience and the experience that I've shared with other judges throughout Texas that we actually have great success with these alternative sentences. Our whole goal as municipal court judges is to make sure that our defendants do not appear before us or another judge in the future. I have had defendants who have performed community service and they've gone on to work for that volunteer, for that nonprofit government entity, or create nonprofit government entities, such as the carpool program at Texas A&M that provides rides to intoxicated drivers in our Northgate Entertainment District. That all started out with a defendant who was performing an alternative means to a fine. I have numerous defendants who, due to terminal illness or some physical or mental handicap, who cannot perform the community service, that I've been able to order a waiver of the fine and court costs, and that has been the best way for me to discharge that fine and court costs. Judges have to be very careful that you don't want to end up in the headline of the news story where they examine your jail and discover that a majority of the defendants in your jail are in there because of Class C misdemeanors, they're indigent, and they never were given a chance to perform an alternative means community service. That is the lesson that still is very important today from Tate v. Short.